We're going to begin panel 2, Fulfilling the Inclusive Promise, Leaving No Student Behind, featuring moderator Mathew McCollough and panelists Jennifer Kurth, Frank Lasky, and Barbara Ransom.
Good afternoon, everyone. It's my honor and privilege of serving as a moderator for panel 2. We have 3 esteemed speakers before us. We have Barbara Ransom, who is a previous awardee of TASH's award that's going to be given to Judy Graham this year. And we also have Frank Lasky and Judy Kurth, who's an associate professor at the University of Kansas. So, as all of you can tell, I'm also a person with DD. I was born with cerebral palsy, and so this plays a role in why I'm doing this particular panel, because as many of the parents, attorneys out there, we have over 100 people here in this room per se, and so when I was younger, my peers fought very hard for me to be fully included inside the regular classroom, and there was an instance when I was transitioning into middle school, into high school, and my parents were asked the fateful question of, so would you want your son to be on the diploma track or the certificate track? And at that time, I had no idea how significant that question would be for me. Because as many of you know, that when it comes to students with disabilities placed on IEPs or sexual floor plans, we are given less value for whatever reason. And so, but my peers challenged that. And but it wasn't until when I went out to college. I went to George Mason University, which is in Virginia, and I took 2 majors. Well, I took 1 major and 1 minor, and the minor is actually a major. So in the Commonwealth of Virginia, there is no education major, but my parents forced me, more or less, to take education as a minor, because when I told my parents that I wanted to major in political science, my mom, who's an educator, told me, what exactly do you do with a poli-sci major? So that was a compromise for me going out to college, that I did education as a minor, but I learned something tremendous during that time. I didn't truly understand or have great appreciation of all of the different laws and policies that were interacting, that basically allowed me to be fully integrated inside the classroom. So over the next 45 minutes or so, we're going to really emphasize the importance of the of an individual with Disability Education Act. We're going to talk about Section 504 of the Rehab Act and the American with Disabilities Act. And I mentioned the 8A because we're celebrating 30 years of the 8A, and during my day job, I oversee the 8A compliance office for the district government. And one of my greatest mentors I noticed was serving as an attending today is Eve Hill. So I want to send a shout out to Eve Hill on this presentation. But at this time, I want to introduce the 3 panelists that's going to speak before us today. And so I want to have the panelists quickly introduce themselves. I'm going to start with Barbara Ransom. So Barbara, please introduce yourself please.
Hi, my name is Barbara Ransom. I'm a parents attorney and been doing disability rights advocacy for about 30 years since I began working in the field. I also worked at the Public Interest Law Center of Philadelphia, the Pennsylvania Human Relations Commission, and Disability Rights California. Right now, I'm a solo practitioner, co-counseling with other attorneys in advocating on behalf of parents of children with disabilities.
Thank you, Barbara. I appreciate it. I would like to next introduce Mr. Frank Lasky. Frank, please introduce yourself, sir. Thank you.
Thank you, Matt, and thanks for your leadership on this panel. My distinction now, I'm an attorney and I just got 50 years in the Bar Association, which allows me not to pay any more dues. How's that? And throughout that time, I've had the pleasure of working closely with Judy and Barbara, and have worked extensively in the topic of education that we're dealing with now in terms of inclusive education and in terms of also community living, and trying to do what I can to help people and their organizations benefit from IDEA, the ADA, and all the other leverage we can use.
Thank you very much, Frank. Appreciate it. Finally, I want to, my internet is unstable, but my Wi-Fi is somewhat unstable, but I'm sorry about that. I want to introduce Jenny Kurth. Jenny is from Kansas. So go ahead, Jenny, please introduce yourself, please.
All right, thanks, Matt. My name's Jenny Kurth. I'm currently an associate professor at the University of Kansas, where I do research related to implementing effective inclusive practices, as well as research around teacher education for inclusive education. And I do teacher preparation. So doing my best to teach the next generation of educators some forward-thinking ways to really advocate for and implement effective inclusive education for students with the most significant support needs.
So the folks out there in the audience, we should call this panel "People Causing Good Trouble." That's what we're all about. We're here to cause good trouble in honor of John Lewis and his civil rights attitudes and approaches. With that in mind, I want to start with Barbara Ransom. My first question that I would like to pose to you, for those new to the general and special education law attending today's session, can you point to specific language or examples within our United States Constitution that speak to the fundamental right for students with disabilities to receive a quality education and access to the education curriculum? And the second part to this question is to the creation and the enforcement of IDEA and ADA. So could you tell all the new lawyers who may be attending this, what gives students with disabilities the right to access the general curriculum, please?
Well, I'm going to start off by saying, especially to new young lawyers, that there are no constitutional rights in our U.S. Constitution that addresses the question of education. Our Constitution, the Constitution of the United States of America, does not guarantee any level of education to anybody. It was not really until the states by virtue of the 10th Amendment, the whole issue of education was something that the federal government did not discuss and did not include. So that was left to the states to decide. And the states, Massachusetts being the first state to determine that, yes, we should educate, we should have public education, and we should make it compulsory. So Massachusetts was the first state to enact any law dealing with education for the quote unquote common people. The last state, of course, was Mississippi to do so. I think they enacted their law around 1917, which lets you know how far away we were. Now, the federal government gets involved in the whole issue of the state rights question regarding education by virtue of its spending powers is the first step. And that was the spending powers allowed Congress to say to the states, by virtue of us giving you some money as it relates to education, we want you to do X, Y, and Z with the money. As a matter of fact, Section 504 of the Rehabilitation Act was the first federal law that attorneys were able to use to argue that people with disabilities were entitled to a free, appropriate public education, least restrictive environment. But in around 1865, you guys know that the Civil War ended. And with the ending of the Civil War, we had 3 great amendments, which I like to think of as part of the list of human rights that the country began to realize that, you know what, we need to look at an issue that goes beyond what we want and look at an issue of what is good for the people. And when I say what we want, I am referring to the fact that this country was founded based on the premise that white landed male gentry were the ones who decided what we want to do, what we would be as a country. And I bring that into the picture because it's so important to never lose sight of that.
Well, wait till I got to be introduced on this thing.
Okay. All right.
Now what
I'm
happened?
sorry.
Yeah.
That wasn't you?
Yeah, because you got to put in that I'm who I am.
So go ahead, Barbara.
Okay.
Go ahead. Thank you very much.
So in any event, with the passage of the 14th Amendment primarily, it's the first time that the Congress grabbed hold of federal protections for people. And it was that 14th Amendment that not only propelled civil rights for people with from racial backgrounds, but has been used again and again and again to ensure the rights of people with disabilities, the rights of women, the rights of people who are not, who are immigrants to this country. So the 14th Amendment to me was the amendment that provided human rights for people, including people with disabilities. I'm sure Frank is going to supplement that with the more specific language as it relates to the ADA, IDEA, et cetera.
Thank you, Barbara. Appreciate it. So I have 2 questions for Frank and Jenny. We'll break it down to the first question. We'll focus on the ADA and the IDEA and the ADA. So equal protection, inclusion, due process, and zero reject are all values embedded in the ADA and IDA. From your perspective, Frank and Jenny, what do these values mean to you, and how do you live out these values personally? So let's have Jenny go first.
All right, I will do my best, and then Frank, you can do cleanup here. So, you know, to me, I look at those as really important sort of human rights, I guess picking up where Barbara left off as well, that we have these really fantastic human rights that are imbued to all people through the Constitution, but then through these laws that really focus on providing protections to people so that they can have an opportunity to demonstrate their competence and their potential. And that's what, as educators, I think we need to focus on, is how can we identify and build upon and create opportunities for people to have and demonstrate competence and potential. I think the other thing that these sort of make me think about is these are values that guide our practice. And so by constantly referring to them and remembering that these are the fundamental things that we're trying to achieve through special education, for example, that we can make decisions that allow us to carry those forward. And so, one of the, I guess, kind of challenges that I see in the field of special education and is this really strict adherence to science, which maybe sounds weird, but there are people who will say we need to be guided, purely by scientific outcomes and avoid, temptations to, adhere to pseudoscientific interventions or something like that. What happens when we do that is when we just follow the science, we decenter the people for whom the science matters the most. We're not making room for building and recognizing the dignity and respect for people. And I think that our research and the practices we do as teachers have to go back to those core values, as you mentioned: inclusion, zero reject, due process, equal protection. If we keep those at our forefront, I think we're going to have room made to not be only focused on, an effective intervention, but really thinking about, does this promote a person's dignity? Does that build their respect? And we want to be able to live those out, through our research and through our education, I think. And so that's kind of what it's meaning to me, I guess.
Thank you, Jenny. Appreciate it. So, Rick, do you have anything else to add to that first question?
Sure. It's just basically, I think, to reinforce what both Jenny and Barbara said, and not to unpack these things, but I think to keep them together and keep them in the forefront. You asked whether inclusion and equal protection due process are embedded in IDEA and ADA. I would say that anybody who reads the statutes and takes them seriously in terms of their purposes, in terms of the benefits they're supposed to provide, in terms of their origin, would say those are explicit. Those are explicit values. Those are values that are fundamental to all those federal laws. And lawyers like to pull apart due process and equal protection and so forth. I like to merge them in a sense and talk about equal citizenship. Barbara and Judy may recall there probably was not an important brief that we wrote that did not include a definition of equal citizenship. And we used to say, the principle of equal citizenship insists that organized society treat each individual as a person, one who is worthy of respect, one who belongs. Stated the other way, it forbids organized society to treat an individual either as a member of an inferior or dependent caste or as a non-participant. I think that says that is at the core. Zero reject is a part of that because it's a counter to the argument. It's counter to the proposition that we had in our schools, for example, that it was a response to the idea that we sort people out, we reject people from full participation, they put them in slots. Prior to 1973, and that's where we start with this, that's where the Constitution came into play. Prior to 73, it was common practice to simply say, you don't belong here. You have to wait. You're not fit. And if you really make trouble for us, we won't even have any classes for anybody. So zero reject really is very important. It means all. And if you move away from all, then you're back into this. Who do we accept and who don't we accept? And when it comes to education, when it comes to important fundamental values of inclusion, we cannot sacrifice that. And I just want to say one more thing, and we can get back to this about equal protection. equal protection does not just stop with treating everybody equally. It's not just having the textbook, it's not just having the classroom. It is taking into account, and this is part of due process too, but it is taking into account the individual needs of each and treating them according to their needs. Not equal injustice for all, but equality for all. And that requires, and we all know, you could go through the 504 language and regulations, IDEA, it's all over the place, that people have to be treated in accordance with their needs and provided the equality that takes into account the variation and the accommodations necessary. It's an affirmative obligation. What it means to me is that when I get into this business, that it is not a place to compromise. It's not a place to defer, that I don't have the right to, cut short on these principles. Inclusion is for everyone. Equal citizenship is for everyone. And
Thank you, Frank.
okay.
Yeah. So well, that leads me into my second question to Jenny and Frank. That how do you work with folks that see we have limited resources and these are great values, but those can only go so far. So how do you ensure that these explicit values that are placed in IDEA and MAA are simply upheld and enforced in our education system and general education curriculum? And Barbara gets stuff in as well. So if you want to expand on how do we ensure that the attorneys, the principals, the administrators truly uphold these values that are simply explicit in our federal laws? I'm gonna call people out. How about if I go back to Barbara? Like, I'm curious to hear what you think about how do we encourage our up and coming leaders, attorneys that are getting their feet wet in this field to truly embrace these values when they are constantly hearing there are limited resources. How do you combat against that?
Well, for me, just like Frank said, I think it's important to express the values. My side of the coin is express the values, but recognize that there's another side over there attacking those same values. That, and I always like to bring it up, especially in these kind of sessions, because if we lose sight of the fact that our values don't always mesh with the values of the people in power at any given time, and we're going to be faced with that, considering what we will have on this Supreme Court or the next Supreme Court. We got we've got a vacancy on the Supreme Court, and I think, just looking at the at who is on the court and who's going to be on the court, we need to be very serious about how we approach the problem. And I love Frank knows I love him to death, and I love all the things that he talks about, because it gives all of us hope to know that there are people with good values and good morals out there who have the ability to fight the good fight. Without fighting the good fight, there's nothing. We need people like Jen, like Bev Evans, like others who are teaching the teachers. We need to be able to support that fight, not just by saying, here's our Constitution, it's really great. Because if you look at the 15th Amendment, regarding everybody has a right to vote, you can't interfere with that right to vote. And you look at what's happening today, and look at what's happening. We had to have a Voting Rights Act to make the 15th Amendment law. I don't get it. But yeah, we need a mixture of people who have the strength, the integrity to fight the good fight, just like we need to recognize that there are some people out there who don't want it to be the good fight.
Thank you, Barbara. So I want to touch base with Jenny because Jenny is on the ground level working with up and coming teachers. And I fully realize that your classroom is fully diverse with different backgrounds, different different thinking and stuff like that. And so how do you rally around that diverse group of folks and say, regardless of where you're coming from or how you view people, that these values of equal protection, inclusion, due process, and zero reject are all foundational values that people should be working from. How do you work with each and every student that may not fully embrace those values quite yet?
Well, I feel like if I knew the answer to really how to do that, I'd be onto something. But I'll tell you that what I try to do is, for example, I'm teaching a methods class this semester. We're halfway through the semester. I have not yet taught them how to do systematic instruction or how to do a prompting scheme or something like that. Because before they can even think about developing technical skills, they need to think about how they should use them, when they should use them, when they should not use them, and how to have these values guide every decision that they're making. And so the things that I'm really trying to emphasize in the courses that I teach to, beginning teachers is that you are a powerful person as a teacher. You have an important, profound, probably lifelong impact on a student and a family. You can use that for good or you can use that for bad. And you all are here because you want to use it for good. And they do. They want to be good people. That's why they're coming to do this. And so really trying to build up their confidence as people who can make a positive change and can have the skills to do that. And so we spend really a whole course in our program actually around teacher advocacy and teacher leadership. And the thing that I try to focus on there is that there's no one better, at your school who knows more about special education law than you do. There's no one at your school who knows more about how to provide instruction than you do. You are the expert that people can come to and act like it. Be a person who's going to be an advocate and an ally for students and their families. That is probably the number one thing you can do. So think about ways you can work within the system and recognize your power as a single person to make a difference. And a lot of times I think, the stars have to align, that there's the right district leader with the right principal with the right curriculum. And if you wait for that, it's never going to happen. So what you need to do is say, what's the one thing I can do today that's going to make a difference? And then you do that every day. And before you know it, you've made a profound difference. And that's what I want them to keep thinking about, how to have these high expectations of themselves and of their students so that every day they're basically proven wrong. Like, I didn't know I could do that. I didn't know my student could do that. But they keep proving themselves wrong and they keep growing and they keep doing amazing things. And that's really, really what I'm after in the teachers that I work with. And, I think sometimes I probably seem totally out of touch and, overwhelming, but hopefully, over the course of time and with some guidance and support, they can get there. And I've been surprised by them too. There's people I think, I don't know if this is going to be a person who finds their power, and I'm often surprised by them as well. And so I really, really am trying to keep focusing on that in my teaching, so that everything is based in values and high expectations and centering the person. And then from there, we can kind of figure out the rest.
Thank you, Jenny. So I noticed that my Wi-Fi is being very super unstable right now, so you may lose me. But I really appreciate your initial comments saying that you shouldn't necessarily rely on the science or the data when it comes to inclusion, equal protection, in my mind, these values are speaking to one's potential in that, and if I truly believe that if the data and the science was applied to me, I wouldn't have been allowed to succeed to where I am at this very day. And so I truly believe that these values that we're talking about, ladies and gentlemen, are reaching to a person's overall potential. And we need to value those thoughts in order to ensure that person reaches the greatest potential. With that in mind, I'm gonna make that switch to Frank because back in 2017, there was a case before the U.S. Supreme Court known as the Andrew F. versus the Douglas County School District. Frank, if you could please summarize the majority decision from the justices, what is the legal significance of Andrew F. decision with displays to the IPs and the IDA enforcement? Please, Frank, take it away.
Okay, Matt, we'll have to do this in a summary fashion. And
Yeah.
but I want to say, first of all, that the Andrew F. materials have been made available. And if there's anything that you read out of this, I think you should read this opinion from the Supreme Court. It was a unanimous opinion. It is opinion which only quotes two other cases, I believe, in passing, and it is just a great unpacking of the statute itself, what the statute says. And it came up, we won't go into the details, but it came up because the 10th Circuit Court of Appeals, coming up from a case in the district court, held that it was okay, the standard for appropriate education under IDEA could be more than merely de minimis. And we use Latin when we really don't want people to know what we're talking about, and we don't know what we're talking about ourselves, but we could think of it as a little more than trivial, a little more than play school. That's okay. This great statute and based again on the constitutional rights we've been talking about is just, more than de minimis. Well, thankfully, Chief Justice Roberts, writing for the full court, no dissent, repudiated that statement and said, as the statute says, the student offered an educational program for merely more than de minimis progress from year to year can hardly be said to be offered any education at all. And then he went back to what the law says. An educational program reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. And in that sentence, which is practically a direct quote from the statute, everything is there. Make progress in light of the child's circumstance. They could have stopped there and we'd still be arguing. But the court went on to look at the great variability of students. Usually cases come up and they're for a particular student. So it's about that particular student. Amy Rowley, for example, was a student who was hearing impaired, was deaf, who was fully included in the classroom. Her case was about what was the extent of the accommodations that had to be provided so she could reach her maximum potential. And they dealt with that case. And courts just fumbled that around for years and years and say, well, that was about that, but it's not about this. This kid is more severely disabled, whatever. So this court, one of the important things about Andrew is that it deals with the whole range of children with disabilities. And to back off this merely more than de minimis, the court focused in one part of its opinion on those people who were with more severe disabilities. The court for the bulk of for people who are assigned to special education said, We want to look at progress from year to year in light of the general curriculum. That's a good threshold. We measure progress that way. And that's the way schools generally measure progress. But what about those who have been set aside and not in the general curriculum and being provided education under an IEP, okay? And we know you're supposed to measure progress under that too. But the court said the goals there, the objectives there, the point of education there was to have ambitious goals, to challenge those students to the extent of their potential. So one important thing there is, again, everybody has to be challenged. There has to be progress. It has to be uniquely designed to the individual. So without getting, we just have to focus on 3 or 4 things. The court said, as it said in Rowley, that appropriate education is a substantive right, and it has to be linked with the general curriculum. Right? Inclusion is the other substantive requirement, and that means starting in the regular class and examining the extent to which a person can be fully included with the full range of accommodations and modifications.
Thank you, Frank. Appreciate it. So, based on what Frank was saying, I have a question for Barbara and Jenny. So throughout your careers, how have you advanced the inclusion education and challenged the low quality education programs and services given to students with disabilities and from diverse cultural backgrounds? So how about if Barbara goes first on this? I know you've been inside the classroom, so please share your experiences.
Well, one of the things that some people don't know about me is that my undergraduate degree is in education, and my initial career choice was to be a teacher. So I took that path for a while and was so frustrated. I wasn't a special ed teacher. I was a general education teacher because back then when I was in undergraduate school, we did not have a school of special education. And personally, I think it was a mistake to take special education and pull it and make it its own school. Because once you do that, you entrench in the culture, the concept that these children are so different that they have to have a different kind of a teacher. The reality is a teacher, and you give that teacher skills that that teacher needs. Now, my experience as an attorney is different than my experiences as a teacher, as you can probably guess. As an attorney, I directly and indirectly impacted other children with disabilities. For example, in a case that one of my early cases was a case in the state of Delaware, and it was Butler. And in the Butler case, Adam Butler was a little boy, African American, who was in Red Clay School District, and Adam's mother worked at a university. One of the things that we did in that case, thanks to some of the teaching I got from Philcott, was to ask for injunctive relief. And the injunctive relief that we requested was that the mother would be put on the state's panel, LRE panel, so that she went from being just the mother of a child with a disability to being one of the people in the state who decided how the least restrictive environment mandate would be implemented in the state of Delaware. So throughout my legal experience, I have always looked not just to that child, but to the bigger picture behind that child, so that we could ask for injunctive relief that would impact not just the child, but other students.
Thank you, Barbara. Appreciate it. So, Jenny, I would like you to respond to that question, but I would want you to think about the next two questions I'm going to pose to you in response to what Barbara has said as well. So, you're teaching mentoring the next generation of teachers. So, what principles, strategies, and tools do you use in building and strengthening your students' understanding of developing process-centered IEPs for students with disabilities? So that's your first question. So how do you make sure that your up and coming teachers create process-centered IEPs that are appropriate for our students with disabilities? Thank you.
All right. Yeah, so definitely part of my role is in preparing the next generation of teachers, and sort of hopefully by having that foundation of mutual understanding around the values that guide our practice. We do really intensive instruction on making an inclusive IEP, which includes everything from present levels through placement decisions and kind of everything in between. And really trying to think about how the educators that I'm working with have the chance to make research-based practices and decisions as they're going through that. One of the things that I did and haven't done again recently is count how many times IDEA and the statute and regulations refers to teachers making or education teams making research-based practice decisions. Research-based decisions. And so I think that part of my job is that teachers need to know what the evidence is, and they need to know how to enact that through these, the lens of the values that we enact. But then my other role is in preparing the next generation of faculty, so doctoral students that I mentor and work with. And our work there really is based on identifying those research-based practices that will guide the field forward into the next, several years, hopefully, so that we can start building a better foundation of research that is grounded in these values of inclusion, dignity, respect, person-centeredness. And that when we have that foundation of research, then we're going to be, I think, better preparing teachers and families and other people to be able to implement it. The reality is that this is a pretty heterogeneous population. And so establishing a really solid research base is very difficult, just given those limitations. And so we need to be, I think, creative and flexible problem solvers as researchers that are hopefully, pushing the field forward. And I do feel like that's part of the role that I have as well, is to identify those practices and share them with the field so that we can keep doing it. And that's, I joined TASH very beginning of my career. And I think that was very valuable to me to have this as the foundation that I've been building on. And I want to have those values continue to carry forward through the next generations of people coming up as teachers and researchers as well. And so I could talk a lot more about an IEP research study that my colleagues and I have been doing, but because we found some very interesting things about how the IEP really is, essentially a document that is intended, seemingly to highlight deficits and position people as being less than and unable to. And so really the work that we have is to reframe what the IEP means as a way of not building a case and a narrative about a student as being somehow deviating from the norm or unable to do certain things, but instead create an IEP that is grounded in this assumption that these are children who will be taught in the general education classroom with their general education peers, learning the general education curriculum. And if we do that as sort of this unwavering commitment to doing that, then we're going to be able to create IEPs that enable us to do it. But if we don't think about that, we're going to keep creating these IEPs that are just centered on creating these narratives of deficit and difference for students, which is just really not helpful to the general cause, I think.
Thank you, Jenny. Appreciate it. So I noticed there are hours almost upon us, so I need to move this quickly on. And Barbara, as you guys know, in the legal realm, sometimes that making sure that the IP is fully ambitious and has appropriate goals, that sometimes we're required to go to the administrative hearings process. And in DC, DC has the greatest administrative hearings rate in the entire nation. It's actually quite sad. And so my question to you, Frank and Barbara, so in your experience, could you tell us, could you speak to examples of when there have been positive and negative outcomes that you've observed going through the administrative hearing process? So do you speak to positive sides and the negative side of taking the administrative process, hearing process? Thank you.
Barbara, you want me to?
Well, you know, you always do the positive, so let me do the negative first.
I'll leave the negative to you. I don't want to talk a lot about the positive, but there really is the greatest satisfaction in the world, particularly around inclusion cases for young children who can start their educational careers in an inclusive classroom, and as you get older, to see what the results really are. But I want to say something about not really focusing on winning or losing administrative hearings. Like many legal processes, the administrative hearings are pretty rare. Full-blown hearings are pretty rare, and the availability of the IEP process and the administrative process serves for the most part as an accountability mechanism, sort of, for parents. And so in many cases, having the courage and the wherewithal and the capacity to take a case to hearing when the school district is deferring, delaying, or compromising, or not doing their job, is an important step, and in many cases will lead to some additional benefit. But as any good attorney or lawyer knows, when you go into a proceeding, whether it be an administrative proceeding or a court proceeding, you want to be prepared to take it all the way. And you want your adversary to know that. And this is an important part of how the educators that Jenny is training can contribute to that. So I don't track wins and losses in terms of any scoreboard, but I do track the advocacy at the initial level of the IEP, and then the advocacy at the next level. So that's.
Well, what I agree with Frank. I think it's important. What is most important for me is like having someone like Jean Gansier by my side, who Jean served a very interesting part in a case that I had in the Central Valley, where she visited that school on a regular, and through her intervention, just by her mere presence, and the school knowing that she would be there to see what was going on with that child. That process kept the child out of the seclusion room for the whole year that Jean did. Jean did this for almost a year out of her own pocket. A lot of times in due process hearings, parents don't have experts. They don't have money for expert witnesses. We need the experts to be there to lay down the foundation. Some administrative hearing officers don't credit the testimony of expert witnesses on parents' side. deferring instead to the old rule of, you know, uh, that, you know, you have 5 witnesses who are saying this child belongs in a segregated environment. Here you come with 1 witness who says, no, they don't. So I'm going to listen to these 5 witnesses who all happen to be the teachers of the child, who all happen to be the employees of the school district, who all happen to believe firmly in segregation. So we have that battle that we have to fight on a constant. But I think one of the things that I know is that when you start early with the school district and you start looking at and challenging, for example, an IEP for functional language skills that say, well, the child cannot move into phonics and phonetics until he learns these sight words. Included in the sight word is a word like telephone. There are no telephone booths in the child's whole town. And I rode around the town to make sure there were no telephone booths. Why did the child have to waste time learning the word telephone and be denied the benefit of a phonics and phonetics curriculum because he did not know or recognize the word telephone? You know, we have to make sure that the curriculum that they say that they're providing to the child is actually being implemented. That's one of the things that having boots on the ground, having people visit the school, having people examine the curriculum, having people examine the implementation of the curriculum. I had Julie Mayer, another educator who went every year that the case was in process, went every year, interviewed the teachers. They got to like her because she was always there, because she was a teacher just like they were. And so we established a relationship there. And those teachers helped make my case for me. We ended up settling the case. And trust me, I'd much rather settle a case than to take a case forward when I know that there's a good possibility that we would lose in an administrative hearing. So there are some good things that can come out of an administrative hearing. And there are some bad things if the parent doesn't have the resources. We know, for example, that the IDEA, as far as the IDEA goes, most of the people who are fortunate enough to be able to take their cases to an administrative hearing that is properly run and has all the things that you need, like the expert to testify, like the time to review the child's placement, that costs money. Most of the people who end up going through that and having the time are middle-class white families. African-American families are sorely underrepresented when it comes to having the issue of whether or not they're receiving a free, appropriate public education, whether or not they're in the least restrictive environment. It's hard to bring those kind of cases and win when you don't have the resources to do so. So that's the elephant in the room, that due process, administrative due process hearings are expensive if they're done right. They cater to parents who have the money, the resources, and the language skills to actually fight the good fight. And that's something that for many African-American families doesn't happen, for many Hispanic families doesn't happen. When we look at the cases that do exist, that have changed the law, and those cases don't even begin to address the issue of that intersectionality of race and disability.
Thank you, Barbara. Appreciate it. So we are at 2 minutes.
I think he's stuck again.
Yeah. Hi, this is
It's
Serena.
morning.
I
So
was here Matt, you had disconnected, but now you're back, so go right in.
all right. So my Wi-Fi is going out. So I'm so sorry about this, guys. But I want to have all 3 panelists, address these final questions. So as you know, students with disabilities are quite diverse. They often experience not only because they are people with disabilities, but they all also experience discrimination based on gender, race, language, sexual orientation. How can the ADA, Section 504, IDA, all of these different civil rights laws, how can they stop these forms of discrimination that's very that exists in our education system? And so could you speak to that? Like, how do we stop these discrimination?
So I think what Matt is saying, how do we address?
Discriminatory practices.
Okay. I think I got
So
it.
go ahead, guys. Thank
How do
you.
we address these discriminatory practices? Matt, we keep losing you on and off. I don't know how to address that particular problem. And there is a really good question in the Q&A. Is evidence-based practice equal science? Curious after your first mention of special ed following science and moving away from centering the students' needs. Does evidence-based practice move the focus off students? If not, can you distinguish between science and evidence-based practice? That's in the Q&A. Jennifer, do you want to address that question?
I can briefly address it. Yeah. So there's standards for essentially evidence-based practices are science-based practices. To rise to the level of an evidence-based practice, you need to have a certain number of quality studies being done to show that a practice is effective. And so, there's a variety of articles and standards written to demonstrate that. And so we have quite a few evidence-based practices, for example, in teaching reading to students with dyslexia, but far fewer for students with more significant support needs. Again, because of the small number of students and the heterogeneous population that you're never gonna, well, you're not never, it's harder to get the sample size to create evidence-based practices for this population. And so while it's the gold standard, IDEA is just asking us to use research-based practices.
I know we're running at our towards the end of our time, but Matt was raising a question that I think is important. We certainly can't answer it, and that it goes back to Claudia's introduction in terms of how African American students, Latino students, other disadvantaged students can achieve the benefits that are in IDA and in ADA and so forth. And the couple things I would say about that is that all the work we do is fact-based and presenting the facts of the double disadvantage of race, of gender, is very important in all the elements. Bringing civil rights claims and education claims together has its complications, but laying out the facts within the case does not. For example, in Connecticut, in our statewide case challenging the regular class placement, the low levels of regular class placement, we also highlighted the fact that there was double discrimination for girls of color, that they were 8 times more likely to be segregated than a white student. And we presented those facts. Whether those facts constituted a colorable claim for discrimination on the basis of race was complicated, but it really didn't matter because the claim was very much more embarrassing to the state than the simple claim that they were segregating kids with disabilities. And so we managed to get some relief, particularly around kids in Hartford and New Haven. So I think it's very important as we go through using both the disability-related statutes that we figure out how to deal with the discrimination, the intersection of discrimination around, particularly around race and gender. And I would add that it's all of the same pattern. One of my favorite cases coming out of the Civil Rights Act was Lau versus Nichols, which involved language impaired, second language students. Makes a very, very strong statement that applies both to disability and to other, in terms of, again, providing the same run-of-the-mill services or education to children who particularly have different needs, whether they be language needs, cultural needs, or disability needs.
Yeah. One of the things I'm curious about, Frank, and I don't know the answer to this question, but I've been looking at including Section 1981 in some of my cases. And 1981 is a pretty powerful little statute from what I'm reading and some of the relief I've seen that people can get from it. Have you ever seen an education case that involves Section 1981?
There are, there have been efforts there, and there have been efforts in terms of, just, let's just use the ADA. We've also had, 504 in the background. The problem, just in brief, is that many courts have interpreted IDEA as covering all the territory, and they're not right about that, first of all. But that has been built up. It's boilerplate in disposing, or just ignoring other claims. It's an area that we have to do much more work in.
For those of you who don't know what Section 1981 is, it's one of the provisions that came out of the trilogy of post-slavery amendments to the Constitution. And Section 1981 has a provision in it that allows for punitive damages as well as compensatory relief. Now, as Frank says, and so when you combine the issue of race and disability, most people will either go down the race track or go down the disability track. And I have found that to me limits relief that would otherwise be available to parents. And by limiting the relief that's available, in my way of thinking, keeps the school district on track to keep doing what it's doing. The harsher the penalty, the more likely it is that the school district will change its ways or hide its ways a little bit more effectively. But at least we need to be waking people up. I've been disappointed by I love Andrew F. On its face, I love it, but school districts have not been doing what they should be doing for the protection of kids with disabilities. And I'm wondering, taking an Andrew F. case on behalf of students of color and bringing in 1981 and Title VI claims, what would that end up getting us in order to properly address the issue of race and disability?
Good question.
So we're down to 7 minutes before we need to do the next panel. Can we cut it here?
Well, that's a question that I'm throwing at Frank. So
Okay.
We can. It deserves discussion. And the other point is we've been talking mostly, and I think appropriately so, about advocacy at the local level in IEP meetings and in hearings and so forth. However, once we see a pattern here, once we saw in Connecticut that we had 5 school districts in and nobody could get it. Nobody could get included. So we had to move to the state. It was a state issue. Every single responsibility that is a duty a local school district has under IDEA, there's a parallel responsibility on the part of the state to monitor, supervise, and ensure that it gets that those requirements are met. And so that requires more, it requires more sustained advocacy. David Shaw, one of the best attorneys in special education in the country, kept on bringing these cases and hitting a stone wall. And that stone wall was the lack of any attention on the part of the state of enforcing basic requirements, even to the point of ignoring federal monitoring reports that revealed gross violations. So the courts are the place. The courts have to be the place where we hold the states and school districts accountable.
Yes.
To provide the will to get it done what should have been done many years ago.
Yeah. And I would agree with that. The reason that I think this part of the conversation is important is because we are also addressing attorneys who are taking this particular seminar for CLE credits, and we should leave them with something to think about and another arrow in their quiver, so to speak, to say, well, maybe I need to look a little bit more closely at that as a potential for creating some change, the change we need to see in the world.
There are some materials, not only from this panel, but in Lydia's panel, and perhaps what we can do is enrich those materials that address the racial disproportionality, suspensions, expulsions, and those issues that are affecting most the racial discrimination in special education.
So we've got 100 people hearing you say this, Frank. So I'm going to be following up with you.
Yeah, well, I'm not composing them. I think it's a question of bringing information together.
Yes.
Civil rights groups are certainly aware of this, and it's been studied, not to death, but it's been very carefully studied, this intersection of race and disability and the double disadvantage or aggravated disadvantage.
So Frank and Barbara and Jennifer, thank you so much for just being an extraordinary panel. If I was a law student right now, I would have been salivating to listen in for the last hour, especially into what was such a provocative, I think, development of a very provocative legal strategy among two amazing legal experts. And then you throw in the tremendous and extraordinary perspective of Dr. Kurth, who is really on the, on the forefront of teaching the next generation of researchers and special educators, and wow. So apologies on behalf of Matt McCollough, who is experiencing some technical difficulties, but we're gonna take a quick break. Donald's gonna walk us into that, and appreciate, again, panel 2.